My name is Scott Thorpe with Kunzler IP Law, and today I'll be discussing employee non-compete agreements under Utah law. The courts have held that employee non-compete agreements are enforceable if supported by consideration, negotiated in good faith, if they're necessary to protect the goodwill of the business, and if they're limited in time and geographic area. This generally means that the employee non-compete agreements are only enforced if they are a condition for being hired or if they are a condition for a significant promotion. Such agreements are almost never enforced if they are signed shortly before the employee is terminated. The key thing to show to a court if you're to enforce an employee non-compete agreement is that the agreement was necessary to protect goodwill or a legitimate business interest. And that means to protect important trade secrets, to protect a special investment in employee training, to protect an exclusive sales territory, something where you can show that the employee has access to something very critical to the business, and if they were able to go and start competing against the business, it would significantly harm the business. It's important to note that this does not include what the court calls common callings. In other words, if, for example, a technician was servicing a client, or if one of several salesmen were calling on a client, these are generally not considered to be legitimate business interests. It's also very important that the terms of the employee non-compete agreement limit the time and the geographic extent. In Utah, that generally means no more than 2 years, although there was a case many years ago where 5 years was held to be acceptable with a very narrow 2-mile radius geographic limit. If you decide to pursue a strategy of employee non-compete agreements, here are some strategies to keep in mind. First, use non-compete agreements with only a very few key employees. If you make everyone in the business sign a non-compete agreement, the chances that those agreements will be enforced is diminished. Second, for those non-key employees, use solicitation agreements. These are also effective, but because they're narrower in scope, the courts are much more likely to enforce them. And finally, tailor the terms of the agreements to the business interests. So, for example, for a junior employee, use a non-solicitation agreement with a very short term, while using a longer term with a more senior employee.